You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can. When you take a half-ass approach to something, you try to do something else. Once you plead, you're stuck like Chuck.
This marks the first real spike in tension. What Norma is hoping for is relief right now, but what the judge anticipates is regret later on. In criminal court, a quick guilty plea might feel like freedom, yet legally it can be a hidden trapdoor. Once it shuts, there's no receipt, no refund, and absolutely no undo option. Ask yourself this: how many people admit guilt simply to make the pressure finally stop?
Solano on today's docket. It looks like she had missed a drug test for bond. We're here for bond violation. Oh yes, Judge. She's here, and she said she was not aware that she had the drug test. I don't know if the manner in which they contact them. I thought they maybe call them for that, but she was originally going to do DWI PTI. She now says she would like to take a time served offer. Would you allow her to do that today?
Why? Why she doesn't want to do the?
She just said she doesn't
know what's going to test positive for. Is that what it is?
No, Judge. But she just said that the expenses of the program, and she's working right now, and she doesn't have time for the program.
Come up, Miss Solano.
But we had already gotten her approved, and we're kind of on our way to. I think we might even have the contract already, even for DWI PTI.
How old are you, ma'am?
25.
Okay. You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can return it or you get buyer's remorse. When you make decisions in here, they're lifetime decisions that you have to live with forever. And, you know, there are collateral consequences.
That statement may sound harsh, but legally it is completely accurate. Judges almost never stop a defendant from pleading guilty unless they believe the person does not fully understand the consequences. This is not anger. It is intervention. The court is essentially saying, slow down before you permanently label yourself. What do you think? Should judges step in like this, or allow adults to make irreversible mistakes?
That may arise, meaning consequences that you may never see pop up as a result of decisions that you make in here. When you plead guilty to an offense, that offense goes on your record and it's there for the rest of your life. And when you plead guilty, you can't take it off. You cannot say, you know what, I have a change of heart. I can't get an apartment. You know what, let me go and try to do something else. Once you plead, you're stuck like Chuck for the rest of your life. I tell you now, I have, you know, every month, people that call me, they go, you know, this lawyer pled me to this case and I can't get an apartment. Can you take it off? I have, like, they pled 10 plus years ago, you know, truck drivers that want to better their life, but they pled guilty to a, you know, a less than a gram case and can never take it off. When you plead to a DWI, not only is it very possible that you lose jobs with regard to, you know, making a living with a car, your insurance is going to go up. Your insurance is going to skyrocket. Insurance is expensive as it is now. You pick up a DWI, it's going to be about 4 times what it is now. Not to mention any other consequence that can arise from a DWI conviction. You have the opportunity now where if you are granted entry into this program, if you complete it successfully, they dismiss the case. It looks like you've already have been granted entry into it. The only problem I see now is that you were called upon to take a drug test and you failed to go. I'm going to go send you for a drug test regardless, right?
Yes, sir, that's fine.
Right. But when you take a half-ass approach to something, you get a half-ass result. And it's usually not a good idea to do that with a criminal case. You know, when you try hard, you get a good result. You know, James worked hard to try to get you into this program.
This is the turning point of the entire case. Negative test results, a second chance within reach, and a clear fork in the road. Short-term convenience versus long-term freedom. The judge is enforcing rehab. He's encouraging reflection, and that's uncommon. So, what do you think? Is this tough love done the right way? or a judge pushing a little too far?
Has she been already admitted into it? Do you know?
She's not in PTI, Judge, but she's been.
Right. But right. I mean,
Yes, Your Honor. The last update was that the contract was signed, the NDA was
all
in.
you literally need to do are two things. You pay the DA fee and you get an interlock. The DA fee, if you fill out a waiver, they may be able to waive that $300 fee. As far as the interlock, I can't pay for that. I can only pay for it while you're on bond. That's something that you'll be required to pay for. But I tell you now, the $50 to $75 cost you per month now is nothing compared to what you will end up paying with the DWI conviction. So you make the decision on what you want to do. I am going to send you for a drug test right now, regardless, and alcohol test. But think long and hard before you make this decision, because there's no turning back from it. Okay? Okay, man. Just hang tight for me.
You want to approach?
Sure.
Judge, we got Norma Solano's test results, and she came back negative. What I was gonna.
Hold on.
Oh, sure, Judge.
Who is it?
Norma Solano. You sent her to go get tested.
Is that Miss Solano?
Yes, Judge. She's right over there.
Come up, Miss Solano.
That's kind of a alternative as opposed to having her plead today. Maybe we can get.
No, I don't want her to.
No, I know you.
She doesn't want to.
She wanted to do time served today, but I was thinking just instead of that, because she's already has the contract, maybe we can give her a couple weeks to talk to some friends and family and see if she would rather go.
What do you want to do?
You said you want to do the time served, or you think you want to do the 1-year program?
Well, I was iffy in the beginning. I just wanted to do the time served, and then I talked to my friends and my family, and they suggested to do the program. But since I got
anytime you can get something dismissed, no matter how, that's always the best result, really, because like I told you, the consequences of a DWI conviction, they're staggering. You never know how it's going to affect you. It will. It's going to affect you. It's just, you never know how and by how much. And with the DWI is big business. You plead guilty, from now on, you're looking at a minimum of 30 days in jail. You're also looking at a mandatory about $6,000 to $7,000 in fines and fees just here from court. Not to mention insurance going up, not to mention all the other stuff in your life, how it's going to affect you. Whereas if you do this program, you do well, maybe they'll even boot you out early. If you do everything speedy, you do it quick, maybe they'll take you out early too. Just depends on how well you do. But you have to put effort into it.
yes,
All you do is, there's 2 classes, right?
There's a couple classes, and then it's the alcohol monitoring device.
And there's 2 classes, a little community service, and just stay clean. That's all you have to do.
I have clients regularly do everything in 6 months.
Take your time. I don't want you to rush into something now. So we'll set you off a couple weeks. In the interim, do we have the financial affidavit so we can have her doing that as well?
I can send you a copy of the financial affidavit to waive the $300 fee if you qualify, but you'd need bills and pay stubs and all that to be attached. I can send that to her, Judge.
Please. And I think we may even have a copy here actually for you. So, try to get that $300 fee waived, and then all you have to do is pay for the interlock and just stay clean. What do you think? We'll give you time. I'll give you a couple weeks. If you still want to do the time serve, that's on you. If you want to do the program, great. It's up to you. Take your time.
I think
Just
Okay.
talk about it.
Take your time.
Thank you, Judge.
I'm glad that you're clean and don't miss again. Okay? All right. Good luck, Ms. Solano. Okay. Great. So I guess we'll roll it to Monday then. Yeah, for sure.
Judge, may I approach? Bobby Steyer. He's got a bond violation.
Ready? Come up, Mr. Steyer.
Not sure why he has this device on his phone.
I don't know, but a bond condition is a bond condition. And when you don't live up to the bond condition, there are consequences, just like anything in life. When you have a criminal case, you have conditions that you have to live by. And when you don't, there are very serious consequences. Mr. Steyer, you're on bond for fleeing a police officer. So. The report is that your device is in lockout, and it's been in lockout since 10/24.
Sir.
Judge, can we address the need for this bond condition?
I don't remember the case, so let's do PC real quick,
Yes, Judge.
and then we'll go from there. All
So
right.
on August 17th, 2024, at approximately 2 a.m., the officers observed a vehicle with a defective tail lamp and tried to initiate a traffic stop. The vehicle had ample opportunities to stop at multiple well-lit parking lots, but drove 0.46 miles of the final stop location. The defendant had red glossy eyes and continuously, I apologize. The defendant had red glossy eyes and the vehicle was running, and the officers also observed a slight odor of an alcoholic beverage from the defendant's body. The defendant had slurred speech and repeated, "I'm just trying to go home. I came from work," but the defendant could not specify his place of work. The defendant denied drinking alcohol, and the officers found an open container of color XO brandy container under the driver's seat and a Taurus pistol under the passenger seat without a holster.
So what bond conditions were on there that they're alleging him to have violated? Let's see. You want to help me out?
Sorry?
This is Steyer,
Yes.
please.
I have one here. He doesn't have any previous violations, it's just that the device is in lockout.
What device?
The ignition interlock device.
So they put an ignition in a lock. I guess the magistrate put an ignition in a lock on it.
Charged with DWI.
Yes, conditions were ordered on August 28th. And
I get it, but he's alleged of alcohol in the car. I don't know. How, I mean, begs the question, why didn't they charge him?
It should have been a deemed UCW judge. We're talking to this officer. It should have been a different charge.
I can't say this should have been a different charge. We're supposed to, officers are officers. We're supposed to allow them to do their job. And when their job doesn't rise to what folk think it should be, then all of a sudden they didn't do their job right. We want to talk to the supervisor. Officer didn't charge him, he didn't charge him. So he only got charged with fleeing. I don't understand why he's got this device on
Did
his
they
car.
do field sobriety tests?
They did not, Your Honor.
There was no DWI investigation done at the scene.
Was there any indication that he was intoxicated?
Yes, he had slurred speech, red glossy eyes.
And an odor of alcoholic beverage.
Yes.
Maybe the officer didn't think it rose to the event. At any rate, the officer didn't call it in as a DWI. And whether the state thinks it's shoddy work or not, we don't punish the defendant because the officer did shoddy work.
Punish them for having bond conditions and not.
I fully understand that. And that's why I wanted to address the need for the bond condition as well as the bond. I understand that the machine's not working or it's in a lockout status, but I'd also like to address why. Why are we having it? So you didn't put it on there.
I didn't, but I think that it's a reasonable restriction when it is, for all intents and purposes, they just didn't charge it because maybe they had an officer that was a rookie, didn't know what they were doing. I can't tell you how many reports that I have see here that might as well have been written in Mandarin, you know?
From the defense perspective, this is.
I understand
the
it.
fact that we have to work with, and if they've got a rookie or if they've got a shoddy investigation, that shouldn't be his fault. Then that's their
But
issue.
it is his fault for not complying
Absolutely.
on conditions. That's what happens now, Mr. Steyer.
Just don't say.
What can you possibly say that can help?
I don't, like I was saying, I don't understand why it's locked. I called the people about it. I told them never like, it's a troubleshoot with your device. We'll try to figure it out on our end. But they never gave me no information about what to do.
He can remedy that today, Judge.
No. I want to figure out now. I'm not going to let him go and then try to figure it after the fact. I'd like to do it now. What do you think? Do you know why it's in lockdown?
I don't, that's what I'm looking at right now. So, because for all of our other devices, we have things sent to them, but since we have third-party vendors for the ignition interlock, I don't see anything on the 24th or past that until the email sent to the DVR.
Would you mind looking into, please, as to why it's in lockout? It might take a little bit.
I
And
understand.
have you take a seat in the jury box while we figure this out, and then maybe 5-10 minutes, we'll come back and we'll
I
see.
understand.
And then,
From the defense perspective, we should still address the need of this. I mean, the officer is part of the state. He is part of the state's witnesses. They didn't make the allegation. They didn't file the charges. I'm still contesting outside of the fact that the machine doesn't work. And mind you, he didn't make the machine. He doesn't calibrate the machine. If the machine doesn't work, that could be no fault of his own, and we can correct that today. But if
let's do this, Mr. Slider.
Yes.
I was going to send you now for a drug and alcohol test. Let's see what pops up.
That's fair, Judge.
See how he's been behaving while he's on bond.
My drug test comes back with nothing on it. It will leave.
Yes. This question is if this drug test is free and clear of any alcohol, any drugs.
Let's cross that bridge when we get there.
We'll do, Judge.
Send you for a test now, and we'll go from there. If you're clean, it'll go a long way for you. If you're dirty, we'll cross that bridge when we get there.
Sir.
My only concern, Mr. Steyer, is public safety. Nothing else matters in my life. And if you're gonna play adult games, or if you play stupid games, you win stupid prizes or you get adult consequences, right? When you act like a child, we treat you like a child. If you do great things, then we congratulate you and reward you, right?
Sir.
Okay, just take a seat for a moment here. We'll be
Thanks,
back.
Judge.
All right, Mr. Slider. So I'm not happy with it. It's unacceptable. It's unacceptable. He's in lockout. A court order is a court order. You know, he's in lockout because he failed to go get it calibrated. Not because of this, not because of that, because he didn't call, no. You failed to go get it locked down, or you failed to go get it calibrated. That's why it's in lockout. I send you to go to test, and now you're testing positive for alcohol. Guess what happens now? That's right. Actions have consequences, Mr. Steyer. He goes with you. I'm sorry, but I can't continue to do it, man. It's unacceptable.
Judge, are you revoking his bond? What are you gonna set the new bonds at?
5,001.
5,000 more than the original bond,
Oh,
which is 5,000.
what's it at now? Is it 100?
Let me check.
It's at 100, so 5,001.
So $5,000 bond, okay,
5,001, yeah, okay.
okay.
Goes with you. All right. Sorry, Kavita, but
It's okay.
it's just too much.
Thank you, Judge.
Sure, Judge.